Good morning. I'm at-large council member Anita Bonds, chairperson of the Committee on Executive Administration and Labor. The time is 12 minutes after 11 a.m. on Wednesday, October the 11th, 2023. We are meeting in room 412 of the John A. Wilson Building and virtually via Zoom to convene a public roundtable on the tip wage reporting and unemployment insurance in the District of Columbia. The hearing is being streamed and recorded on the committee's YouTube channel named EAL Committee or on the DC Council website. The purpose of today's roundtable is to address two topics: the status of implementing the tip wage portal and the administration of the unemployment insurance program. Through this process, we will be evaluating the scheduled launch of the tip wage reporting system as required by the Tip Wage Workers Fairness Amendment Act of 2018, enacted into law on December 13, 2018, which means that the fifth anniversary of the act enactment is approaching. Today, we will also provide an opportunity to discover why the implementation of the reporting system has been delayed. The Tip Workers Fairness Amendment Act of 2018, passed by the Council, requires the quarterly reporting of wage paid and tips received by tip workers to the Department of Employment Services. Additionally, to expedite the filing of these required wage reports, DOES was to create an internet-based portal. The purpose of creating a tip wage portal was to accept the submission of electronic spreadsheets with wage information instead of requiring the manual entry of data, and to be a user-friendly platform that enables employees to easily report alleged wage theft violations. The Tip Worker Fairness Amendment Act of 2018 repealed Initiative 77 and required the following: an easily accessible internet website that describes the various district wage and hour and anti-discrimination laws, the launch of a public education campaign to raise awareness and educate the public about the rights of tip workers, and the creation of a staff tip violation line to receive complaints specifically related to wage laws in the district. And lastly, an additional requirement was to create the Tip Worker Coordinating Council, which I know is up and running and would like to hear more about today. The status particularly of how it is progressing. We also were scheduled today to learn more about the unemployment insurance process. We have on board today public witnesses, but we will not have our government witness, as the director of the Department of Employment Services is unavailable because of a family issue. She is unavailable to us today, and we wish her well at this time. So we will not examine the topic of unemployment insurance, but we will hear from our public witnesses as it relates to their concerns about the implementation of the tip wage portal. And so with that said, I will like to acknowledge any of my colleagues that may be on with us for their opening remarks, and then we'll move right to our public witnesses today. All right, we will start with our public witnesses, Mr. Robert Brennan, and then we'll move to Shay Rudell Tabisco, who is the Director of Government Affairs and Member Advocacy at the Restaurant Association of the Metropolitan Washington. And then we'll hear from David Julian regarding the National Payroll Reporting Consortium, and James Alphonsus, owner of various DC restaurants. And I hope I didn't butcher anyone's name too much today. All right, so we'll start with Mr. Robert Branham, ANC Commissioner, I believe still. Mr. Brennan? Okay, he is not. Okay, everyone else is here. All right, we'll now hear from Shay Rudell Tabasola. Mr. Basola, please move forward with your testimony.
Thank you, and good morning, Honorable Committee Chairperson Bonds. It's a real pleasure to be here. My name is Che Riddell Tabasola. I am the Director of Government Affairs and Member Advocacy for the Restaurant Association of Metropolitan Washington. And RMW thanks you for the opportunity to provide comment at today's tipped wage reporting and unemployment insurance roundtable. At the outset of our comments, I do want to express our appreciation to the work of the Department of Employment Services and its director, Dr. Unique Morris Hughes. We believe in very much support the department's mission to foster fair and effective working communities. One of the issues to be raised today is that over the summer, a number of our members, local neighborhood restaurants, family-owned and operated small businesses received letters alleging a really serious crime, which was wage theft. However, in the cases that we reviewed, these were not actual wage theft problems. These were due rather to flaws in the wage reporting website or rounding errors, and certainly by not any malicious intent of any operators. I only have a couple minutes today, so I'm just going to talk about a couple examples that we reviewed here at RMW. First, regarding a defect in the wage reporting website. One of our members received a notice that it underpaid its employees thousands of dollars. However, on closer look, the discrepancy was not due to theft, but rather to a computer error that moved the decimal place 2 places to the right, meaning that an hourly tipped wage of $4.45 an hour showed up as being paid $445 an hour. Similarly, another hourly wage of $5 an hour appeared to be paid $500 an hour. Clearly this was a computer error, but the restaurant was still accused of wage theft and asked to pay fines of thousands of dollars. Second, and I believe related to the first, is that the errors found were levied excessive fines way out of proportion. For example, one restaurant was found to owe one employee $1.40 in back wages and a second employee of 45 cents in back wages. But that restaurant was asked to pay a fine of over $100,000. Now, on review, the Department of Employment Services reduced both of those fines, but I would argue that we shouldn't have been in that place to begin with. I'd like to share 2 last points before I close. The first is the law requiring reporting the tipped wage clearly says it's the obligation of the payroll provider. However, to date, the department has clearly placed that responsibility on the restaurant operator, and that was never the intent or the letter of the law. I think if there's some confusion or lack of clarity around that question, it would be fair to ask the Office of Attorney General for his read on the law. And the second, and probably the larger one here, is that this is really unfortunate for a bigger reason, because these sort of things really smear the industry at large, right? For any individual, being paid fairly and accurately is tied to our dignity, right? And ensuring that is taking place is certainly worthy of scrutiny. However, what happened here this summer, and especially in terms of the process, is the exact opposite of that. I think if any of these letters of determination were carefully reviewed by an individual, we would not be here today discussing this. The department and the director care very much about equity, and to be sure, women and communities of color are unfortunately subject to unfair and unjust working conditions. But these letters that alleged wage theft also were sent to women who own and operate their own small businesses, to entrepreneurs of color and hardworking families who are creating the jobs in our communities. My last point is that these individuals, the employers creating these jobs, deserve just as much care and dignity in this process. And that's what we ask for moving forward. I really appreciate the opportunity to share comments today. Councilmember Bonds, as always, we're here to answer questions and to be in partnership with you and the agency moving forward. Thank you.
Thank you very much for your testimony. We'll now hear from Mr. Julian.
Thank you, Madam Chair.
Mhm.
Madam Chair and members of the committee, I'm David Julian, and I represent the National Payroll Reporting Consortium. NPRC is a nonprofit trade association whose members provide payroll processing services to over 3 million U.S. employers, including over 20,000 district employers. NPRC shares the Council's commitment to ensure that tipped employees are properly paid and has explained in detail why the proposed DOES portal plan would not effectively identify wage underpayments. NPRC has offered established alternatives that would meet the Council's intent at no cost to the government. We've shared these concerns and alternatives with DOES for several years. For the past several months, DOES has advised NPRC that reporting via their new portal would begin soon, but that specifications weren't yet and still aren't available. NPRC has consistently asked for at least 6 months of lead time to develop and test the software changes that would be required. We still haven't received the specifications for the portal, and the last we heard from DOES was in August. How'd we get here? In 2018, as the Council addressed I-77 issues, there was an 11th hour amendment that required district employers to use payroll providers to submit tipped wage data to the Office of Wage Hour Compliance. Payroll providers were not part of those discussions or deciding on that language, and therefore the proposed tip reporting language had fatal flaws. DOES then went on to interpret that language and came up with a proposal for how NPRC members would report on tipped wages through a to-be-designed portal. Since 2018, NPRC has on more than a dozen occasions explained to DOES in detail, number one, why their approach would not accurately identify wage underpayments without substantial additional staff time and cost to DOES. Number two, that the DOES proposal, even before the I-82 repeal, was so unique in the nation that the cost of modifying software and systems would likely result in NPRC members leaving the district market. This was first shared in writing with DOES on October 10th, 2019. DC is a bit more than 0.5% of NPRC clients. And finally, that an established working alternative would work in DC and at no cost to the district. DOES did not engage in a serious discussion of alternatives for several years and said the portal program was not in effect because of lack of funding. More recently, they said they were now preparing to implement the portal, but milestones and deadlines were consistently moved back to the present. DOES and NPRC have had several discussions this year regarding the portal. While DOES has made a few adjustments to their original plans, NPRC has still never seen the specification for the portal, despite DOES's statement that it will be forthcoming. As I mentioned, the last communication from DOES was on August 29th, in which they said, quote, hoping to get a status update this week regarding the draft specifications and time schedule for the next round of system testing. That didn't happen that week, and there's been no communication since. DC tipped wage will be repealed by 2027 and possibly even sooner. A realistic approach to ensuring that tipped employees are properly paid during this interim period is doable. The data to verify proper pay is located at the employer's site. If an employee believes that there's an underpayment, filing a request with DOES can result in an inspector going on site to review the records and resolve any dispute. While any underpayment is serious and needs to be addressed, the likely number of filings and the process to follow up during the next few years should be manageable. And if DOES needs to temporarily hire additional personnel for this interim period, the council can consider providing those funds. DOES hasn't been responsive to NPRC, nor have they addressed the very real and serious issues regarding the following. How many complaints should be expected in an average month? How many complaints did you get last year? Will your approach provide a final answer without additional staff time and cost? What cost will this place on NPRC members, district employers, and DOES for a 1 to 3 year project? What changes did you make with the passage of I-82? What alternatives have you considered? Perhaps the committee will have better luck. NPRC remains, as always, prepared to work with DOES, employers, and employees, and this committee to find a proper solution to reporting prior to repeal. I'm prepared to answer any of your questions and engage in this discussion with DOES, except I understand they won't be here. Thank you for your time and consideration. That concludes my testimony.
Thank you for your testimony. And I think before we go to Mr. Alfantis, it would be appropriate for us to just examine a couple of things, Mr. Julian, that you mentioned. I think you are indicating that as of today, you still have not had conversations with the agency, Department of Employment Services, about the specifications of the portal. Is that correct? Or are you saying you had some conversations and you haven't seen the final plan?
The latter is correct. We have had conversations. We have never seen any specifications.
All right. And the specifications that you believe will help us get to having an operative portal, have you submitted those in writing? And if so, would you please submit them to the council? Submit it to me, please.
Yes, ma'am. We have submitted several times detailed explanations of what would work, including what's currently happening in Maryland, so that they could see. And we have already, I will confirm that we have provided the committee with all of that material.
All right, you will confirm. Okay, please, if you have not, please provide me with that material. Perhaps it was provided in years past. My tenure with this committee just began in January, so.
Yes, ma'am.
I
We'll send it to you.
apologize.
I'll resend it to you today.
Thank you. Thank you so very much. I also wanted to just make sure, now, when we talk about the current process that you use as the third party that is reporting the information to DOES, how are you doing that? In what format are you currently reporting it?
Madam Chair, I believe that at the moment, NPRC is not reporting. We have not reported any changes in tipped reporting. As the restaurant representative explained, this is still being required by the employers. In other words, the implementation of the payroll provider sending in this information has not happened yet, because the portal through which we're supposed to do it doesn't exist. And so it's my understanding, but I qualify that we need to confirm. It's my understanding that only the employers are currently providing tipped wage information. We provide other information, but not the tipped wage.
All right, so you are, as far as you know, you're not involved in reporting the tip wage information. I guess I was kind of misinformed. I thought that you were doing it and it was still being done manually. Maybe that is the smaller restaurateurs that are reporting independently that are not using your service, because I know some of this tip wage reporting is taking place because DOES has levied some fines. So I'm trying to get a handle on who's using what system.
Right. I believe, again, to be confirmed, but I believe, Madam Chair, that the answer is all of the tipped wage information that DOES is currently getting is only coming from the employers, that the 2018 Act that mandated the NPRC members provide that was to go through that portal, which has not yet been brought online.
Okay, well, you leave me in a query then, because we're not, it sounds like we have a law. The law is making certain requirements. The requirements are perhaps not being met because the system that the law requires is not up and running. Yet we as a government are coming up with a fine system, and we are levying these fines appropriately. Is that what I'm hearing, Mr. Julian, from your perspective?
That's my understanding, but I think that the restaurant probably can speak to whether or not their members are doing this or providing all of the submissions directly.
All right. Thank you very much. Mr. Tebasolas, can you respond to that question, please?
Yes, ma'am. So per the law, the payroll provider is supposedly required to enter the information. As Mr. Julian said, the portal by which to do that is not prepared. And so what has been happening to date is individual operators have been submitting the information to DOAS via the website.
Okay, so there is information that's coming into the agency.
Yes, ma'am.
It's just not using the portal. All right, okay. So that is how the government is enabled to levy fines.
Yes, ma'am.
Okay, so they are getting information. Well, thank you very much. I could ask the Restaurant Association, what level of hardship does this current situation present itself? But I think you've been pretty descriptive of what may be going on. I'm very concerned about the fines. And I'm also concerned with this situation as it relates to not having, well, having a part of the law that we can implement, and the other part of the law is not yet implementable, so to speak. Tongue-tied here, but trying to understand what should be the responsibility of the Restaurant Association at this time and its members at this time as it relates to being in compliance. Let me ask, is there a sense of from the Restaurant Association that the reporting of the information should get to DOES, whether or not there is the established portal or not?
No, council member, the law clearly stated, and the intent in the letter of the law was that a portal would be established, and that it was the payroll providers who would report that information. And it's because this information is that important. We do want to make sure that individuals are being paid fairly, and that's why this was put in place.
So you are holding fast that without the portal, your members cannot be in compliance.
No, we are. It is a pretty burdensome process to manually upload that data. You can also upload a spreadsheet. But to take a step back, the obligation, the law was written for payroll providers to provide this information, and that is not happening.
All right, and so can the interpretation be that the payroll providers are in fact the institutions or the enterprises that hired the workers?
No, I don't believe so, ma'am. The restaurant operators hire the workers. But again, if you read the law, it clearly states it is the payroll providers whose responsibility is to report the tipped wage information.
Okay, and yes, and the interpretation, have you, just hold 1 minute, please. All right, well, thank you very much. We were just checking on one aspect of the law. Um, Thank you for your testimony. And if you want to stick around for a minute, we're now going to hear testimony from Mr. Alfantis, who is the owner of various DC restaurants, and you might want to contribute to his testimony.
Hi, I'm James Alfontis. I'll speak on that subject too to answer. So the third-party payroll provider is a company that I would hire to run my payroll and make sure I've been in business for 20 years. So over that time we had Paychex and now we use Gusto mostly. And we give the information to the third-party payroll provider and they provide that information to the IRS and DC, et cetera. So the portal is brand new to us and we don't use it and because we have no instructions on how to. And as far as I know, our payroll provider isn't using it either because they have no instructions of how to do that either. But I think that's maybe not the subject of my testimony. But I'm happy to take any questions. I think what I'm here for is a little bit of maybe like real world experience. So just quickly, I won't take too much time and I'm not here to level a bunch of complaints, but hopefully I can just shed a little bit of light onto a real world experience in a way. I'm a lifelong DC resident. I opened Bucks Fishing and Camping, my first restaurant in DC that I owned by myself 20 years ago this week, and it was named a DC Classic in the Washington Post. And then I own Comet Ping Pong, which is I opened 18 years ago this week, and I have 2 other restaurants on the same block open within the last 4 years. So that's 4 restaurants. I grew up in DC, as I said, and I employ over 70 people, most of whom are DC residents. It's a very diverse group of people, waiters, tipped employees, cooks, chefs, payroll providers, managers, office people, bakers, etc. So we run a weekly payroll. We pay our employees every week. Their checks are picked up on Tuesdays. Our payroll obviously is in the multi-million dollars for all the places of these small DC independent restaurants. So thank you, council, for hearing from me. We were also one of the restaurants who received this determination that we were in violation of their tipped wage violation, that we had underpaid our employees in 2 of my restaurants. So we received these letters. And in some way, I think that my testimony here today is to provide almost a victim impact statement as to, the failure of an implementation of some programs. So it's a sort of a word of caution, I think. I was thinking about this, and the idea of a victim impact statement is not new to me. My restaurant, Comet Ping Pong, was the subject of a wholly invented inaccurate internet conspiracy theory, which resulted in a gunman coming to this restaurant in 2016. And my victim impact statement in that was delivered to a federal courtroom with Conjay Brown being the presiding judge at the time. So that was very scary. And in 20 years of business, I've obviously had, this isn't our first time getting a letter from the DC government regarding some matter of our business. This one was particularly frightening because, we got a determination that was delivered via certified mail that the managers opened that had my one restaurant assessed $172,000 missing back wages and an $807,000 fine attached to that as well. So it was over a $1 million fines for just this one restaurant. And then a few weeks later, another one of my restaurants received over a $400,000 combined back wages and fines. Obviously, as you know, this was all eventually, I guess, figured out. I'm not quite sure that something went wrong. And so at the time we spent like 5 months unraveling this all with a lot of expense and stress over that period. So that sort of has been my experience with something going wrong. So the subject, I guess, of this hearing is more of the tip wage portal, which I think is so far confusing, to say the least. So as we do in every one of our businesses, we're like fully compliant with every single DC regulation, and we're happy to abide by them. But it's helpful if there's not like gross errors, and if we don't, and if we're informed and trained on them, and if there's clarity in the law, or its implementation. So that, if I can answer any questions, I'm more than happy to. Thank you.
So thank you very much. I think you pointed out that we may have a law, we have this law in place, but we have not completed creating the system for compliance. And that's very, very unique, I must say, in the grand scheme of things, because yet we're moving forward with levying the fines. I was interested in how the agency's interpretation of the law, and their interpretation is clear that if you're in this business and if you hire and pay tip workers, that you are required to report it to the government. But the law seems to be it seems to be broken at this point. So it makes compliance very, very difficult. And I appreciate getting that information on the record.
Thank you.
Just wanted to spend a little time this morning inquiring about, the impression that the vendors in our restaurant industry have, their impression of how this law is to be utilized and whether or not it is really available to them at this time. May I ask about your compliance? Do you feel that you are required by the district government to report the wages that you pay to your tip workers?
Yes, to answer that question, it sort of speaks to what the Restaurant Association representative was discussing, and I think well stated by him. We do report all of the tipped wages, but it's through our payroll provider. For any independent, the idea of an independent restaurateur, unless they have 1 or 2 or 3 tipped employees, to be independently running their payroll is pretty unheard of these days, and it's super difficult because if any person you pay, is paid at the state level, at the federal level. Social Security taxes are all calculated and taken out. So almost everyone uses a third-party payroll provider, and we provide the provider with the tips that employee has received, and then the taxes are taken out of that in the appropriate way. And we assume that the third-party providers are required to, be in compliance. So we're in compliance, they're in compliance, and we're constantly checking on each other in a way. And if we receive any notice, it's of course goes to the top of the list of things we're dealing with. So I'm not sure how this reporting portal would make a change to that. And I think just one more part of that is, a law is, I think, as I understand it, is sort of the compliance and the enforcement of that law is the value of that law in some ways. So I'm not sure if there's a compliance level that isn't already checked by a more verifiable audit, or checking in with a restaurant or employees reporting missing wages as has been discussed.
All right, I thank you very much for that. So now I have to ask Mr. Julian, as the primary representative of many of the restaurants in the District of Columbia, you have heard that from a restaurateur that their goal is to report their payroll through the third party, and you're representing a third party process. And by reporting, if a restaurateur reports to the third party, their impression is that they are in compliance. And so when it comes to you or to your organization that you're representing, I think the interpretation is that that organization would move that information into the agency. And whether it's through a portal or if it's old-fashioned paper, quite honestly. So that's where we have the disconnect, I sense. Now, prior to and now, without the portal, what is your organization saying about how it currently reports or is treating as in its role as a third party payroll provider?
We are in compliance with the laws that, as was explained by the restaurant rep, they provide us with data. We take that data as the payroll provider, and we create both the payroll and also all the reporting to all the various agencies. And we continue to do that every day now. What's different is that in 2018, for the first time, DC pulled out the tip wage report and said, this report is separate, and we're going to create a new way to identify it. And we're going to put for the first time, we're going to put the payroll, we're going to tell the employer that they have to use a payroll provider to provide this tipped information. First time it was done. So in 2018, and by the way, NPRC is neutral on all the policies. Our job is just to take what the law says and to follow the law. In 2018, for the first time, the district through DOES said that the payroll providers will create a separate report on tip wage activity and provide that through the portal. Because the portal isn't up, we're not doing anything with it. As explained, the restaurants are still doing it. 2 points I'd like to make. It's absolutely correct that in 2018, the burden was put on the payroll providers to report tipped information through the portal to be designed. But that portal wasn't designed initially because DOES said they don't have the appropriation. And we said from the beginning, even in 2018, you've done this wrong, and here's all the explanation why. And that was given to them in October of 2019 in detail. I would propose to you, though, Madam Chair, that the situation in 2020, in the fall of 2023 is the following. We now know that tip reporting will be repealed in no more than 2 or 3 more years. And there's an effort to move that date up. So what we're now looking at is what's the appropriate way to handle tip reporting for this brief interim period that's realistic and cost efficient and gets the information to DOES so they can identify underpayments, proper underpayments. It's not going to be with the 2018 law. We've explained that even now, although we haven't seen the spec, since October 10th of 2019, NPRC has provided a detailed explanation to DOES why their proposal won't work. And if they proceed with it, NPRC will leave the market. Today, it's different. You only have a couple of years at most. And some kind of a mechanism, as we're proposing, can be put in place to ensure that tipped employees are paid the proper wages. But it's not going to be the portal. It just isn't. And what we've asked for years is for DOES and the restaurants and this committee and NPRC to sit down and come up with a pragmatic solution to identify this very important issue in the context of the repeal. And that's what hasn't taken place.
Thank you, Mr. Julian. Just one correction, not this committee. This is a new committee.
Yes, I'm sorry,
And
Madam Chair.
yes,
You're
it's
absolutely-
okay. I
you're
understand.
absolutely right.
Yes, you have made it very clear to our government on numerous times. This is an opportunity for you, if you could sort of summarize what you are proposing as a solution at this time. I would love to get it on record.
Thank you, Madam Chair.
Mhm.
We've asked and we don't know yet from DOES what is the number of complaints that they've had or that we need to handle in this time period. It's our understanding that that all the data on tipped wages resides at the employer site. That's where it is. And that's where it sits today. So during the interim before repeal, if an employee feels that they have been underpaid, they should be able to make that known to DOES. DOES can send somebody to the employer's site to look at the records and determine whether or not there's been an underpayment. The number of cases, and that is the simplest plan. The number of underreported claims we're not aware of, but we understand it should be a manageable number. We've shared this with DOES. They haven't responded at all. But we believe that the data exists on site right now. We don't have it yet. The data exists on site. If there's a complaint, go to the site, look at the data, and make an answer. We're only talking about a couple of years. If they need a couple of additional employees to do that, that's something that the council could address in terms of appropriated funds.
All right, and on the issue, what is your thoughts about how the tipped wages would be reported? Because that's another part of this, a requirement where the wages go into the portal. So absent the portal being available, what is your solution for that?
The solution for how the payroll providers could provide tipped wage information to the government without a
Yes.
portal? I don't have an answer. We'd have to look at it. I don't know.
Okay, again, back to the antiquated approach of using paper. Is that a solution? Or maybe taking a report that you received from a restaurateur, making an electronic copy and forwarding electronic copy to the agency? I'm surely there are some very specific fields of data that must be collected. And so if the agency had a format that they could share with the third party industry. The third party industry would just simply fill that out and submit these reports in that manner.
Madam Chair, as noted, NPRC is ready to sit down with all the impacted parties and look at what could be done. Absolutely. Including what role we can play.
All right, I appreciate your willingness, and I'll ask if there is any other ideas, either from the industry or from the Mr. Fantas, if you have any thoughts.
Yeah, I mean, I think that representative from David Julian had it pretty correct. The payroll provider is there to follow the law. So if there's a way to provide that report, they would provide that report. But since there's not, it's difficult for us to provide. And the information is in the reports we're providing now. Like when you pay a tipped employee, you report their hourly and all of their tips. So the information exists. I'm not sure, you know, how it's best delivered to DC.
All right, I appreciate that. My goal is to think through or to really suggest a methodology that takes us past this portal so that we are still getting the information so that the government can appropriately act on it as needed. So I appreciate any comments whatsoever. Chad, do
we
you have
appreciate
any
you
thoughts?
looking into it too.
Yeah, thank you.
Councilmember, my colleague Andrew is very well versed in this, and he's been working on this since day one. So I'm sure he has some ideas that we'll follow up with in writing with you following the hearing. But just like Mr. Julian, we are here to be partners in this and to work collaboratively with the agencies and everyone else here and arrive at some solutions.
Well, thank you very much. Just one other area that I think we should try to touch on today, and that is the area of fines. You mentioned how the fines seem just somewhat outrageous for the amount of the violation, the dollar value of the violation. Do you have any thoughts on that you want to put on the record today?
Sure, Councilmember, and I'll clarify, these are the alleged violations. Like I had said, I think a number of the supposed wage theft, it was due to computer errors, like I explained, rounding errors and decimals being placed 2 places to the right by the computer. And I think, in just the handful of cases that we've reviewed, there's enough evidence to support, are any of these alleged reports accurate, correct? But like I had said, some of these fines, and like I said, $1.85 in underpayment resulted in $108,000 in fines. Secondly, a $3 underpayment resulted in a $217,000 fine. Just excessive, not in proportion to the alleged theft, if that indeed occurred, and purely punitive. I will share that it does appear that on appeal, DOS is lowering some of these fines, but they're not waiving them. And arguably, these fines should have never been levied to begin with. And keep in mind, a number of our operators
I think the feed is down. We're missing your testimony. Ms. Tabuso. Mr. Tabuso, okay.
I could speak to this.
All
issue
right,
very
thank you.
directly if you have a second.
Yes,
I mean, for instance, due to I guess computer error, which I'm still unclear what went wrong, but we were, as an independent operator or any operator, the idea of having that we had underpaid $172,000, which is a lot of money for any one restaurant. And then an $800,000 fine is like, in the, it's like half our income. It's a lot of our income. And there seems to have been, that it was already determined, and then there was no real way to undo it or appeal. And then there was an appeal. So it took 5 months of, any independent restaurateur paying, legal fees and accounting fees and your accountant and your bookkeeper and all of these things to get out from under this error. So that's, I mean, it's pretty kind of scary, gross incompetency that really put like myself in fear and also my employees in fear, because there was sort of rumors going around my very well-established 20-year plus restaurants that we were had been fined the DC government over $1 million, and there's potential of us closing. And then these people would lose their jobs, in which case their jobs, they would have to go find another job, some of which had worked here for 15 or 14 years. So it was like embarrassing and damaging to the psyche of the DC worker and to us. So, and to me. So it just like, it was a scary moment for everyone. So that's part of my testimony.
All right. Let me just ask, is there a formula that you know of that is used to construct the level of fines?
If you're asking me, no. I mean, then on the same document, they were reduced because of the timeline that had passed. The timeline that I was faced with was Q1 of 2020. So it had been a number of years, so it was reduced by that. But that timeline was, Q1 of global pandemic, the restaurants being shut down. So it's very confusing to have to go back in that and figure it out. But it turned out it was an error. So to the point of if other restaurateurs, and we sort of heard rumors about other restaurateurs being focused, this happening to them too, which was sort of reassuring, because then we thought, oh, maybe it's not just us. But I would imagine, I think it's an important point to note that, as I said, I have 20 years of experience here, and I have a great customer base, and we have a long established community of people. And this isn't my first time getting a notice from DC government. But if I were more independent, more on my own, or a newer business, or a struggling business, or a more disadvantaged business, I think that there's a potential that something like this, fines, would scare me away, or put me under. So if other businesses are being hit with fines that are inaccurate, I think there's a real obligation for DC to go back to these people and work with them to figure out whether or not these fines are accurate. Because and another note, it is very difficult to find employees who are willing to work in these businesses in a way, and train them and bring them along and give them the support they need, and then try to provide other benefits. I imagine there are very, very few employers who would want to steal or are able to take or mispay their tip employees. So, the waiters and the tipped employees expect to make a certain amount of money, or they will go work somewhere else. And I think they are aware that they could report underpayments to themselves. I think they are aware of that. And there are requirements that make have us make them aware. So I feel for these other businesses who weren't able to spend 5 months of their life like I did unwinding 2 major, almost $2 million fines. So I put it back to GC to be proactive on getting out from under these. And I have to thank the director of the DOS, who I eventually, at the end of 4.5 months, went directly to and sort of begged to get out from under the stress of these things to please intervene. And at that point, within a few more weeks, we had kind of gotten it figured out. So there is action, but I would encourage, I feel for the businesses of DC.
All right. Well, I'm looking at a copy of the law, and it says that the mayor shall assess a $100 fine for each day an employer fails to meet the requirements of this section. And of course, this section is an employer that complies with its obligations as set forth in other sections of this section shall not be required to comply with the posting requirements set forth in the following laws. Section 106 of the Living Wage Act of 2006, Section 251 of the DC Human Rights Act, Section 12 of the District of Columbia Family and Medical Leave Act, Section 7 of the District of Columbia Parental Leave Act of 1994, Section 10 of the Accrued Sick and Safe Leave Act of 2008, Section 106I of the Universal Paid Leave Amendment Act of 2016, Section 10 of the Minimum Wage Revision Act of 1992, Section 5 of the Building Services Employees Minimum Wage Week Act of 2016, Section 5 of the Protecting Pregnant Workers Fairness Act of 2014, Section 37 of the District of Columbia Workers' Compensation Act of 1979, and subsection of this section shall not be construed to mean the requirements of this section as optional. And so it goes on, but it's clear that there is a set fine amount of $100, and that I am going to take as the way in which, or the methodology used by DOES to establish the fines. I might ask of Mr. Tabasola if this is the interpretation of the Restaurant Association as to how the fines are identified or classified. Oh, I'm sorry, he is not able to reconnect. All right. Okay.
I hate to have, on the letter that was provided to me in the initial determination, it's based, you're accurate, is that according to this, is the number of employees that they claim was claimed was 15. There's a statutory penalty amount of daily failure to pay of $50 on this letter. The number of days of the violation was 1,076 days. So I guess that times 50 is $807,000. So under the letter I received was a $50 a day penalty.
All right. So then I have to ask you, Mr. Elefant, why were 1,076 days allowed to pass before you heard from the agency? What do you have to say about that?
It seemed just outrageous. I was very confused. Also, you know, there were glaring errors in the document, like employees, the same employee listed 4 or 5 times. One employee that had worked, you know, the DOES had claimed they had worked 4,000 hours during the quarter. And so right away, when we started looking at this, we're like, well, how did this employee work 4,000 hours? And if you just simply calculate the number of hours in a quarter, it adds up to around 2,700 hours in a quarter, every minute of every day of the quarter. So we're like, well, this is impossible. Like this is obviously an error. And for it to take years to come back is that. And then on the same letter, basically it's reduced administrative penalty assessed. So DOES took the $807,000, and because there had been 1,076 days had passed, they recognized that, and so reduced the penalty to you know, to a $45,000 penalty. So it was $172,000 in back wages and a $45,000 penalty. So it was, you know, $250,000 fines showing for that one company.
All right, I will not ask you on the record the status of that bill at this time.
Oh, I can answer. I mean, I think
All
it's
right,
very relevant to answer them both. So, what we did was, this began in June and it was resolved in September. So, June, July, August, September, I contacted DOES, we notified them of the mistake. I spoke to the people in the office there. They were responsive and helpful. They sort of acknowledged that there was something is wrong, but we weren't sure what. We filled out forms. We sent in copies of everything we had filed. Everything we had filed matched everything in the DOES system. We went into DOES systems and looked through, matched them all up, provided all those documents to DOES. Eventually, like I said, we were heading toward a trial date of some sort, a hearing date. So we filed all the paperwork in order to, be present at the hearing and make our case at the hearing. The hearing date was getting within a few days. We were overnighting and certifying mail to the court system. And I reached out to the director of DOES and asked if she could intervene, and it seemed to help. And there seemed to be a more of a response. And eventually there was a final determination that these were completely inaccurate. We owed no money to the DC. We had not underpaid any of our employees, and that the tips were all paid correctly and reported correctly. At which point we were still scheduled to go to hearings. So then we had to file with DOES to notify the court system that we were voluntarily removing this, the need for a hearing. And then we had to make sure we got letters on that. And frankly, I live in a little bit of fear still that, it hasn't been completely sort of expunged from these systems. But we went through all the due diligence and did a lot of work to get to the fact that we had done nothing wrong and a computer error had occurred or something. I mean, I'm not sure exactly why this happened, but luckily I don't owe $1 million to DC for any of this. And my employees, I'm sort of reassuring to the employees, and in fact, told them that I'm providing this testimony in order to make them understand that, they're safe, their jobs are safe, and we're in compliance, and we will continue to operate. So thank you.
thank you very much for that. It's very descriptive of the process, and I'm glad to know that things certainly have worked out. I'm just a little concerned about this setup and how it's being implemented without all aspects of the law being in progress. So thank you very much for that. I truly appreciate it. I see that Chet is back with us. And so I had asked the question if there were some further thoughts about how we can be assured as a community that the Restaurant Association members are in compliance with the law that exists, without the technical part that stipulates a portal as a process for filing information. So I wondered if the Restaurant Association had some ideas. I got some ideas or suggestions from Mr. Julian as to solutions and information he will also forward to the committee. And we'll take a very close look at it. But I wondered if the Restaurant Association has some thoughts that you want to put on the record today.
And thank you, council member. I'll say at the outset that, and James had sort of spoke to this as well. Our teams who work in our restaurants are the hearts and souls of our operations. And there is a myth out there, and unfortunately the course of these letters over the summer just really worsened it, just really smearing the whole industry that somehow operators are out there to take advantage of individuals. And the very opposite is true. These are our teams. They have been with us from day one. They have grown the business with us. As we have succeeded, we've seen them succeed and take on more responsibility in these roles. And that's really the truth for the vast majority of operators. I'll say the law, again, I'll come back to is very challenging because it clearly states that is the payroll operators who should be providing this information. Operators are doing it in lieu of that at this moment. But again, that was not the intent of the law. I think Mr. Julian made some very good points and some good comments that we'd agree with. And we look forward to working with you and the committee and the agency to get this right and to better implement the law.
All right. Well, I want to thank you all. On that note, we will recess this hearing until a further date. As I mentioned, the department was unavailable today due to, an emergency, to be honest. And so I want to give the agency and any other witnesses an opportunity to come to the table at a later date. So you'll be hearing from us. So at this point, I'm going to officially recess for a date uncertain at this moment so that we can continue this dialogue. But I want to thank you for your testimony today. It's been very, very helpful. And we will probably have a report regarding, I'll say an interim report until such time that we can continue the hearing, that will make the interim report available to the public. So thank you again to everyone, and thanks to my team here at the committee. And with that, I'm going to gavel down for the recess.